Welcome to TFC Transplant Talk, where you'll find the most up to date information on topics that matter most to you and your loved ones. Join us in our engaging recorded interview series between transplant healthcare professionals and families living the transplant journey. We are your partners in transplant information, improving the lives of both the recipient and everyone around them.
I'm an attorney here in San Antonio. I was with Catholic Charities here in town for nearly 4 years, but now I'm in private practice, and I mainly specialize in the area of guardianship, adult guardianship, but I also help families with less restrictive alternatives to guardianship. And if you're kind of in this legal world of guardianship, you'll hear that phrase a lot, less restrictive alternatives, because the Texas Estates Code, the law that governs guardianship, asks us as attorneys and asks judges to look at less restrictive alternatives, because the idea is we want an individual to retain and keep as many rights and freedoms as possible. And so if there are less restrictive alternatives to guardianship, we want to consider those and have families consider those too before we just immediately jump to guardianship. So I'm going to talk about some of those things. And but I also do help families do the power of attorneys and wills. I also handle probate matters when someone's passed away. So those are the areas that I specialize in, but the guardianship is probably the main area that I work with. So I mentioned the Texas Estates Code. So if you're wanting to kind of see what laws are on the books regarding guardianship and less restrictive alternatives to guardianship, you'll look to the Texas Estates Code. And you can, of course, Google that, and you can kind of read some of those statutes if you'd like. But it actually defines what an incapacitated person is. Okay, it's someone because of a physical or mental condition is substantially unable to do certain things, provide food, clothing, or shelter for himself or herself, care for their own physical health, or manage his or her own financial affairs. Okay. Now, obviously, sometimes with a young person, there might not be much to manage as far as financial affairs. Maybe they're just getting their monthly SSI income. But if there are other areas where they cannot, take care of themselves or handle certain things themselves, they may meet this definition of an incapacitated person. Okay, the person who's under guardianship is called a proposed ward, or simply just person under guardianship. Okay, so what are some less restrictive alternatives to guardianship? Well, the power of attorney is one option. There are two main types of power of attorneys: a medical power of attorney and a financial power of attorney is the other one. Those are legal documents. I help prepare for clients and families all the time. And I'm going to talk about those a little bit more in detail in a second. Representative payee is, many of you may be the representative payee, or for your son or daughter. Again, those SSI payments that come in, you help manage them as the payee. There's also, I'll get into some of these too, but you can do a joint bank account or a convenience account, which I'll go into more detail here in a second. Special needs trust, or it's also known as a supplemental needs trust. ABLE account is relatively new within the last 5 years or so, and supported decision-making agreement. Okay, so these are just all examples of when I'm meeting with clients and families for the first time, and they say, well, we need a guardianship. Okay, well, let's talk about that some more. Maybe you do, but have you considered these other alternatives first? And because the judge will ask that you consider these options first as well. Okay, so medical and financial power of attorney. Many of you may be familiar with these documents, so I'll just briefly touch on them. But a medical power of attorney is, again, a legal document where you're selecting someone you trust to serve as your agent to help you make medical decisions. But the key is it's at some point in the future if you become incapacitated. So it's sometimes known as a springing POA. And springing, and so the idea is it springs into action when you need it. Okay, so when you're incapacitated, then that agent, that person you've assigned to help you, can step in and help make medical decisions. Okay, financial power of attorney is similar, but it's obviously the person is helping you make financial decisions or banking, legal decisions. Okay, so you might present this to the bank and say, well, my son or daughter has appointed me as his financial power of attorney agent. So I'd like to be able to help make decisions for him if he needs it. And this document, so hopefully that document the bank will accept, and you can kind of help out at the bank if needed. One key difference on the financial power of attorney is you can make it effective immediately. Okay. Or you can say, like the medical power of attorney, this is only effective if I become incapacitated. Okay. So you do have the option of making that effective immediately, which is nice if that's maybe the situation you're in. A couple notes: power of attorneys are revocable at any time. So unfortunately, sometimes you can imagine there may be a falling out in a relationship, and you say, well, I don't want this person to help me anymore, or I don't want this person to be my agent. Well, the individual who signed it to begin with can revoke it. A guardianship, okay, at some point, if maybe you start with a power of attorney and it's not working, or you run into some obstacles and you feel like you need a guardianship, well, the guardianship would revoke the power of attorney. Okay, so that's one thing to keep in mind. And the principal, the person who signed the document, can still make decisions too. Okay, that's one thing I think sometimes people can confuse it. Well, now I can make all the decisions for this person. Well, no, they've just said you can help and you can make some decisions, but that person can also make decisions too. Okay, so just keep in mind that one caveat. And then the power of attorneys are not effective after death. So sometimes, usually involves an elderly person. Maybe the son or daughter comes in and says, well, I'm going to make all these, I'm going to go to the bank and do all these things. Mom passed away, but she made me her power of attorney. Well, sorry, those power of attorneys aren't effective when somebody passes away. That's when you look to the will and other documents. So representative payee, again, some of you may already be the representative payee for someone. An organization can also be the rep payee. Like at Catholic Charities, we were the rep payee for about 15, 16 individuals. So their SSI income would go into their bank account, and we would use those funds to pay their bills, and then maybe give them a kind of a small cash disbursement, once or twice a month, so they could get their, groceries or incidentals. But but if you're, you may already be the rep payee, so you're already familiar with this. But one thing to keep in mind with a rep payee or SSI benefits, once your child turns 18, they're reevaluated. Okay, now they're an adult, and family income is not considered any longer. Okay, so SSI or Social Security would just look to that individual alone and what their income is. Well, if their income is nil or very minimal, well, they may get more of a benefit there. Okay, so, and to be honest, just as a disclaimer, I'm not an SSI expert, but the Social Security website is there, a couple websites there if you're wanting more information. And okay, so moving on to, we talked about the bank accounts. Again, you can do a joint bank account, obviously, where let's say you and your daughter are both on, you have a joint bank account. Okay. Y'all are co-owners. You can both do the same things, but there's also a convenience account. The convenience account is kind of a nice tool where you can, you're on the account, um, but you're not necessarily an owner, a co-owner, but you can write checks, you can pay bills, you can perform other banking functions on the account. Okay, so again, sometimes you'll see this also um, with elderly individuals say, well, you know, mom has advanced Alzheimer's or dementia. I need to be able to write checks from that account to pay her bills. And so it might be a convenience account, but I could, you could still, you could do this with a young person as well, I think. Um, so supplemental needs trust or special needs trust. I usually refer to it as special needs trust, but supplemental needs trust is synonymous, but or you can just say SNT. So that's just kind of that's the abbreviation. But the SNT is a trust that allows individuals with the disability to keep their assets, okay, while protecting their income based benefits, okay. So say, for example, someone receives inheritance, okay, or receives money in a lawsuit settlement, and they're on Medicaid. Well, if they go above that $2,000 income threshold, they might be kicked out of Medicaid. Okay. So that income can be placed into a special needs trust while protecting that individual's benefits. Okay. So it's a very effective tool to, again, you can still get some, you can still get assets, but to protect Medicaid and SSI, and you need to, you might need to put those into this trust. Okay. The Arc of Texas is one organization that provides, they have what's called a master pool trust where families, have their own little individual trust account that they can put money in. So that's just one organization. You might, you could also, there may be banks in town that could do something similar, but the Arc of Texas is pretty reasonable, I think, as far as their fees are concerned. So, but if you want to Google Arc of Texas, you'll get more information about their special needs trust program. Okay. Okay, ABLE accounts. Now, ABLE accounts is pretty new. It's started in 2015. It was federal legislation, and then Texas had their own legislation that was passed in 2015. An ABLE account is essentially a savings account, okay? So again, I mentioned that $2,000 threshold, right? If your son or daughter is on Medicaid, well, you can't exceed that $2,000, right? So let's just, again, that example of, well, they inherit some money from an uncle or grandparent, or there's a lawsuit settlement, okay, a personal injury settlement or something, for example. Well, you get this you get this windfall. Well, I don't want them to lose Medicaid. Where do I put this money? Well, you could also, in addition to the special needs trust, you also might want to look into the ABLE account. Okay. You can put up to $100,000 in an ABLE account, and Medicaid and SSI are protected. Okay. However, you can only put up to $14,000 a year. Okay. So, and then again, once you hit that $100,000, you can actually put up to $370,000 into an ABLE account and still protect Medicaid, but exceeding the $100,000 may lose that SSI benefit. Okay. So you could put more than 100,000 and still keep Medicaid, but you may lose SSI. Okay. So there's just some things to keep in mind. But again, it's just kind of the other nice benefit is that family members, grandparents, aunts, uncles, they can contribute money into that account. But again, it just can't exceed that $14,000 a year. And there are limitations on what the money can be used for. There's kind of a laundry list of things, but education, housing, transportation, those things are okay. You can pull money out of that account too. But texasable.org, you might want to check out for that. Okay, supported decision making agreement. This is relatively new as well. In a supported decision making agreement, the person who needs help chooses someone called a supporter, okay, to help them get the information they need, excuse me, they need to make an informed decision. Um, so I kind of see it as like an advisory board. Excuse me. It's a document, okay, like a power of attorney, but it doesn't necessarily give the helper or the supporter any kind of legal authority to act on that person's behalf. Okay, again, you're more an advisory board. You give advice, you provide input, but the idea is that you're just kind of there waiting in the wings to help out if needed, but the individual is really kind of making all the decisions themselves, and you're there to provide support and help. Okay, so may not be for everybody, but something you want to look into. There's a website here, or you can Google supported decision making agreement. Okay. All right. So just again, kind of a summary of less restrictive alternatives to guardianship. I didn't really mention supports and services, but that's kind of another catchphrase you'll hear. Um, um, you know, the judge or the judge may say, well, are there any other supports and services that might prevent the need of a guardianship? Well, supports and services are, maybe there's individuals receiving physical therapy or occupational therapy, or you're getting meals on wheels, so other kinds of supports and services that might avoid a guardianship. Okay, but supported decision making we talked about, and power of attorneys. Um, okay, so guardianship. Guardianship is a court ordered relationship. Okay, so you have to go through the court. It does require that you hire an attorney or retain an attorney to do it. So you couldn't represent yourself, you couldn't do it pro se, but so you'd have to hire an attorney and go through the legal process to get a guardianship in place. And a lot of times, so it's a little intuitive, right? Well, because the parents, when I meet with parents, say, well, why do I need a guardianship? Why do I need to go through the courts? I've been my, son or daughter's guardian for 18 years. Why do I need to do this? Well, obviously, as you know, in Texas, when you become 18, you're an adult. And that so you have your own freedoms and rights as an adult. But obviously, we know that there are certain situations where you need to continue to be an advocate and help your son or daughter. So a guardianship, a legal guardianship through the courts might be necessary, so you can continue to do that. Okay. So again, it has to be proven that the ward, okay, the say young person is incapacitated because of a mental or physical condition and is unable, I think I already touched on this, but is unable to substantially provide for their own needs. And that less restrictive alternatives, like a power of attorney, for example, are not feasible. Okay. So somebody who can't understand or sign a power of attorney, well, then they might need a guardianship may be needed. Okay. A guardian may have full or limited authority depending on the ward's incapacity. Okay. And what I mean by that is that you can tailor a guardianship. A full guardianship, which I'll go into the rights here in a second, so I'm just going to save that. But just keep in mind that you can have a full guardianship and a limited guardianship, and I'm going to touch on that here in just a second. But what are qualifications to be a guardian? Well, you have to be at least 18 years old. You can't have, you can't have notoriously bad conduct, which, some of these kind of offenses below, you can't be, convicted felon, and so these are some things that made us, some of these specific convictions would disqualify you. Okay. Um, all right. Moving on to other qualifications. There can be a conflict of interest in the sense that, you can't owe the proposed ward any money, or they can't owe you any money. Okay. So there'd be a conflict of interest there. There can't be maybe another ongoing lawsuit. Okay. Where, you know, you're suing the person that you're also wanting to be guardian over. Okay. So there's a conflict of interest there. All right. So there are certain qualifications and disqualifications to being a guardian, but who may serve as guardians? Well, excuse me, you could be, now you can't have co-guardians. Okay. Now the only relationships that provide for a co-guardian are parents, obviously, husband and wife. Okay. So let's say if it's maybe mom and stepdad. Okay. Um, it's husband and wife, and then joint managing conservators. I haven't had that situation come up, but it is possible where you have, both parents who are divorced, but they're joint managing conservators, and they could also be co-guardians. Okay. So a lot of times the question comes up, well, let's say I need a guardianship. When do I start the process? When do I start all this? Okay. The guardianship isn't effective until the individual turns 18. Okay. As far as like when we go to court and have a hearing, well, all that happens after they turn 18. Now it could be on their 18th birthday. It could be the week after. Sometimes we don't get a guardianship in place until the individual turns 19. Okay. Which is fine. But you can start the process before they turn 18, but it can't be more than 6 months before. Okay, so I would say maybe 4, 5, 6 months before your son or daughter or whoever it is that you're looking to maybe apply for guardianship over. You'd want to kind of start that process, no earlier than 6 months before they turn 18. Okay. Now I mentioned going back to what I mentioned about you can have a full guardianship or a partial or limited guardianship. Okay, well, what I mean by that is that in a full guardianship, here are some of the main rights that ward may lose or may be restricted. Okay, voting, driving, determining their own residence, making decisions regarding marriage. That's not to say they can't get married, but as guardian, you would kind of have the final, say on that issue. They can't own firearms or ammunition. They cannot consent to medical, dental, psychological, or psychiatric treatment. They can't handle financial or business affairs. Now, so when a ward, all those rights are restricted, well, it's probably considered a full guardianship. Now, let's say an individual can vote and they can drive. Let's just use those two as an example. Well, you can say, okay, well, we want to continue to be able to make medical decisions for this individual, but we want them to be able to vote and drive if that's an option. Okay. Okay. So you would just tailor the guardianship application and the guardianship order to provide, say, this individual is going to retain the right to vote and drive. Okay. And so that's why it's considered a limited guardianship. We're asking the court to retain some of those individuals' rights. Okay. Any other rights that not expressly restricted in the court order? Okay. There's actually a document called the Ward's Bill of Rights. Okay. Which talks about all the rights that the ward still has, even if they're under a guardianship. Okay. Okay. Well, so the main piece of medical evidence used in a guardianship case is called the Certificate of Medical Examination. And it's just a boilerplate form that as attorneys we give to clients, and the parents take their son or daughter to the doctor. The doctor completes the form, and we submit that to the court with our application for guardianship. One thing to keep in mind, if at some point you you do need to apply for guardianship or you consider a guardianship, it has to be completed by a doctor. Now, because sometimes we get the form back and they're filled out by a PA or a nurse practitioner or someone who's, it has to be a licensed physician, okay, um, to do the exam and to do the form. Okay, so sometimes I get the form back. I say, well, I'm sorry, if this is a nurse practitioner who did this, we need to have the doctor do it. So we have to kind of send that form back, and it's usually not a big deal, but it has to be filled out by a doctor. Now, on that form, it asks, is the proposed ward, in their opinion, totally incapacitated or partially incapacitated? Well, if the doctor says partially incapacitated, it might be we ask for a limited guardianship where the individual maybe retains some of those rights we talked about. Okay. Is improvement in the ward's physical condition and mental functioning possible? Well, if the doctor says yes, improvement is possible, well, that suggests that maybe at some point in the future, we don't need a guardianship. So I've had the courts, the doctor filled that, checked out, yes, improvement is possible. Well, the judge will see that and again, it's like, okay, well, maybe we don't need a guardianship. Let's come back in 6 months. I'm going to order the guardianship now, but in 6 months, let's come back to court and see if we still need this guardianship. Okay. And again, that's not a big deal, but we, you might have to go back to court if that's the case. But now, the only, and again, this is kind of a little bit of nitty gritty, but this medical report can't be 4 months older than the date the application is filed. Okay, so sometimes I have somebody will contact me, can you just send me the medical form? Okay, well, okay, so I've sent them the form and they get it filled out, but they don't contact me again for like another 5 months or something. It says, okay, well, we're ready to file the application. Well, unfortunately, that form is more than 4 months old now. So we have to go back to the doctor to have a new form filled out with a current date on it. Okay. So that's just one thing to keep in mind, that you don't want to get this form filled out and then not do anything for 4 or 5 months, and because it might be outdated by then. Okay. I already touched on this, but it's again, just there are different variations of guardianship in the sense that you could have a guardianship with limited authority. Okay. We talked about that, where the ward retains certain rights. Okay. Powers and duties of the guardian. Okay. Here are some other powers and duties that you have as guardian. You have the right to have physical possession of the ward and to establish their residence. Let's say the individual that you're guardian over is in a group home and that group home isn't working out and you need to move them and put them in a new group home. Well, as guardian, you have the authority to do that. You obviously provide care, supervision, protection, provide them with food, clothing, medical care, shelter. You do have the power to consent to medical, psychiatric, and surgical treatment. The only exception, though, is you cannot consent to the ward being committed. You can't say, I want this person committed. Okay. And again, it's obviously a mental health issue, which I won't necessarily touch on today, but there are other things that you have to do to get that person committed or at least evaluated. Okay. If there's a mental health situation. The power to establish a trust. We talked about that. You have the power to establish like a special needs trust for that individual. Okay, and moving on. Now, at the end of all this process, and the process itself, it kind of varies, to be honest with you. I mean, it could take, maybe on average, maybe 5-6 months. It could be quicker. It could be a little longer, depending on, say, one thing you have to do is you have to give notice to biological parents. Well, maybe if one biological parent is out of the picture and we don't know where they are, and we're trying to find them and serve them, or maybe have them sign a waiver or something. Those kind of little things can sometimes delay the process, but but normally it's, I'd say at least a couple months as far as kind of from start to finish. But at the end of it, we go to court, we have a brief hearing before the judge, and the court issues you this form, and they're called letters of guardianship. And again, it's just a form, but it's a official form from the court that you would show to any third parties that you're the guardian. So if you go to the doctor and say, well, your son is 19 years old now, and I understand you want to be in the exam room, but he's an adult, and due to HIPAA and other regulation, privacy issues, you can't be in the room anymore. Well, that's not the case if you're guardian, right? You have the authority to be in the room because you're the one that the court has ordered to make medical decisions for your son. All right. So this is the document you'd want to show anyone, just to say, I'm this individual's legal guardian, court-appointed guardian. Okay. That form expire after 16 months, but all you have to do to renew it is just submit an annual report to the court. It's just again, kind of a boilerplate form that you fill out every year, and just to kind of give the court an update on how the individual is doing, just give them an update. Okay. And then you can get the new letters. So that's my presentation. This is my email here, my phone number. If you have, questions about guardianship or less restrictive alternatives, feel free to contact me or get in touch with me through Travis. But I'm going to stop sharing now. And so if there are any questions, feel free to ask.
Hi, I have a question.
Okay.
Sorry. If you can, if you can kind of touch up on the power of attorney, because I know that's kind of common. But my question is, I've heard there's a durable power of attorney, there's a medical power of attorney. When usually you're at the hospital, do you have an advance directive? Can you give a little bit of more information on that?
Sure. Yeah. So the medical power of attorney, again, is you're appointing someone to help make medical decisions. And you're right. Sometimes when you're admitted to the hospital, they'll ask you, well, do you have a medical POA, or do you have an advance directive? And so, hopefully you have family members who can come up, or, sometimes people will have those documents in a flash drive or something on with them. But yes, those are tools, because the doctors and hospital, they want to know, okay, well, if you're under anesthesia or you're in surgery and we need to do something, who do we contact to consent to whatever we might need to do? So that's with a medical POA. The advance directive, which, yes, I didn't go into my presentation today, but the advance directive is another important legal document where it's a situation where if you're in the hospital and you're at that very last stage of life where doctors have said, we've exhausted all treatment options. You're no longer, you can't make decisions anymore. Let's say you're in a coma and doctors have said, this individual has maybe weeks, maybe months to live, but they're at that very last stage. And the directive, you're saying, if this situation happens, I don't want life support. I want to just be kept comfortable. Okay. Or some people say, I want life support if I'm in this situation. So you're kind of looking to the future when you're drafting the directive, saying, if I'm in this position and I can't decide this anymore, here are my wishes, here are my preferences. Okay. So I think it's a good document for really anybody to have. I mean, obviously we see, maybe more, we have elderly individuals who come in and who maybe say, well, I've been putting this off for a long time and I need this in place. Cause maybe, but I encourage it for anybody, to do like a will, power of attorney's directive. will. Those are all good things that I'd recommend to anybody just to have in place, because you never know. You're in a car accident and you're in a coma, and doctors have decided, well, we either need to, take this person off life support because we don't think that there's, you know, any, they're not coming back to, they're not going to ever be the same person again. Um, or do we keep them on life support? Well, without that advanced directive document, you might have family members who think totally different things. No, mom would want life support. No, mom would not want life support. She would just want to be kept comfortable. Let's not do life support. But then you have families, trying to figure out what mom would want. But that advanced directive kind of says, look, guys, here's what I want in case I'm ever in that situation. Okay. But as far as the durable power of attorney, it's also, I refer more often than not to as a financial power of attorney, but it's the same thing. Financial power of attorney and durable power of attorney, that's the same thing. It's just, it's just, it addresses more the kind of financial legal matters.
And if we want you, would you be able to draw up those power of attorneys for us? If so, like, does it take a long time to do it? How would your fees work with that? If you can give us a little bit about that information.
Yeah, sure. I do them for, yeah, if individuals want to contact me, those documents are pretty easy to do. Just, I need obviously information about who you want to be your medical power of attorney agent or your financial power of attorney agent, the person that you want to help you. It's usually always also a good idea to have like a backup person. So you might say with a married couple, say, well, my husband is going to be my primary agent, but I'm going to have my son be my backup agent. Okay. If for some reason my spouse can't help me, I'm going to have this person. Okay. So, but yeah, if someone wants, if someone's interested, if they want to contact me, I won't necessarily get into kind of details on my fees and things here, but I do, for a reasonable amount. And because again, it's just, I'm drafting the document, and then, you do have to usually get those notarized. The directive, it's also encouraged that you have that witnessed too. So you have two witnesses and a notary for the directive. But the power of attorneys, you just want to sign those in front of a notary. But yeah, I'd be happy to help if anybody needs those drawn up, or, sure.
Now let me ask you, we had a parent ask about, I had never heard of this, like when their child is 18, but they're still in school, that they're being limited to what they can see on their school records at the age of 18. With a power of attorney, would they have the authority to be able to take in either the durable or the medical and show it to the school and say, okay, I have power of attorney? Should they be able to see all that information?
Yeah, that's a good question. I've done on a few occasions, there's a kind of a tailored POA called an educational power of attorney. And so I've done that a couple times for parents and who are in that situation, right? They go to an ARD meeting or they go to some kind of meeting and they say, well, you can't be in the room anymore. Your son's 18 and he needs to make his own decisions now. Well, if you feel that maybe you still need to be in the room and help make those decisions, you could possibly do an educational POA. Now, the only caveat I would have with that is, now they still have to, the third party, the administrator or the teachers, they still have to accept it. Okay, they still have to honor that. Now, hopefully they will, but I haven't used it enough to kind of have a sampling of feedback where say, well, yeah, I presented that, but they didn't care. They still wouldn't honor it. But hopefully, you have that legal document in place that says, my son has asked me to help him make educational decisions. And he signed this form appointing me as his educational POA agent. Okay. And then, so again, hopefully you have that legal document that'll provide the authority you need to do that. But again, I haven't used that very many times, so I don't have a real strong sense like, it's like, yeah, it works every time. But it is an option.
Let me also ask, I know you talked about that medical document, the CME. Can can that be done by like your own private doctor, or does it have to be done by a specific doctor?
It can be done just by any licensed physician now, because yeah, some people maybe they have multiple doctors that they see, like a neurologist or a specialist or some other specialist, or it could just be kind of just, yeah, just your pediatrician or just general family doctor. It doesn't specify on the form that it has to be this type of doctor, this type of specialist. All it says is it must be completed by a licensed Texas physician. Okay, and that's the only thing sometimes, again, where the physician's assistant filled it out or the nurse practitioner is like, well, then we have to take it back and say, we really need the doctor to do the exam and to complete the form. And so that's just from the Texas Estates Code requirement. But
Oh, thank you. That was really great information. I appreciate it. Does anyone else have any questions? I just want to make sure.
Laura, what were the fees for those papers?
yeah, again, if I don't necessarily want to get into kind of specifics on my fees on this presentation, but if someone wanted to contact me, email me, I could give them a list of kind of the fees that I would do that for. I mean, all I can say is I try to keep my fees reasonable. But yes, if someone wanted to reach out to me directly with my email or through Travis, or I'd be happy to. I just didn't want to put those specifics on the recording.
Okay, thank you. Thank you. I really appreciate all the information. It was great. This is going to be good for all the families to have. Thank you for your time.
Yeah.
Thank you for your time. We really appreciate it.
You're welcome. Thank you for the invitation. And yeah, hope everyone has a great day.
You too. Thank you.
Thanks so much. Everyone have a great day.
Bye-bye.
Bye.